No, are we going to shift over to music now?
The blurred lines case?
Blurred lines and music in general.
Okay, we can.
So,
go ahead.
okay. So the good news, the one good thing that I have to tell everybody today is that when it comes to music, the claims are still alive and well. And the reason for that is very simple, and Judge Wilson talks about this in his New Girl case, which is he says screenplays is for the general audiences, and anyone can tell whether there's similarities in screenplays, etc. I think that's completely wrong, and I think Robert here agrees with me on that. I think writing a screenplay and comparing screenplays is an art form that judges should not think that they can supersede or supplant their own expertise, if you will, for those of experts and screenwriters. Fortunately, in music, they don't do that. In music, they defer to the experts. So the good news is, over the last couple of years, you've had some great music decisions where plaintiffs in music cases have actually been succeeding. There was one last summer where the court actually found just the beat of the song to be enough. It's not in our materials, and I don't have it, but yeah, I think it might have been a little bit more than the beat. It might have been the beat and maybe.
Was that enough to survive a motion to dismiss, you mean?
Yeah, a motion to dismiss or a motion for summary judgment. And then
it sounds like Blurred Lines.
No, it wasn't Blurred Lines. It was another
that's
case.
Essentially what Blurred Lines was.
I want to say. No, it wasn't the Usher case either. I should have brought it with me today. But anyway, great decision. I found it from the Hollywood Reporter, so it came out in August of 2015. Blurred Lines, I mean, me and Jay disagree on this, but I mean, I think, Chris, you agree with me that the plaintiff should have won the Blurred Lines case.
I mean, we were like, oh, wait, it's not.
Uh-huh. So, I mean, we think the Blurred Lines decision is wonderful because it's actually perhaps the first time a copyright infringement case has made it to trial and the plaintiff has actually won in like 40 years or something. Interestingly enough, one of the cases that Robert was talking about, the Shaw versus Lindheim case, did make it to trial and the plaintiff did win, and then the judge did a judgment notwithstanding the verdict.
Yeah.
So even though they made it all the way to trial, it actually went up to the Ninth Circuit, back, got all the way to trial, and won. They ultimately lost. And of course, Metcalf versus Bochco, that happened.
Put a little asterisk by the Blurred Lines because it's actually the defendant who won in a cross-claim because the plaintiffs were seeking declaratory relief.
Right. Put that asterisk there. So fortunately, they defer to experts in music cases. And if you have a music case, you do have a shot of actually getting it to trial.
Well, what about that? Because Judge Wilson's been getting a lot of bad press here, but in Counts versus Merriweather, when the motion for summary judgment was first brought, he actually didn't dismiss it. He asked for further briefing, or not further briefing, and he asked for expert testimony. That is a literary infringement case, but he's also said that generally, as you said, Steve, you don't, and other judges have said, you don't need expert testimony. Everyone knows, anyone can read a script and tell the similarities and differences between them. But a judge would never decide a case like that without expert testimony in a music case.
Yeah, let me just read the portion real quick for the audience. This is from the New Girl case. The court also notes that expert testimony is far less critical in a case such as this, where the works are targeted at a general audience and deal with subject matter readily understandable by any ordinary person, including the court. Here, specialized knowledge is not required to dissect the objective components of the copyrighted work. Compare Swirsky, which is a music case, relying upon expert testimony comparing the objective elements, pitch, melodies, bass lines, tempo, chords, structure, and harmonic rhythm of musical works. So judges, or at least Judge Wilson, thinks that he's good enough to be able to dissect a screenplay. And I would respectfully disagree. I think writing a screenplay is an art, and that they should defer to the experts on these issues. And there was quite a bit of expert testimony in the New Girl case.
Anyone can offer an amateur decision. Everyone has opinions on movies. Everyone
Sure.
thinks they know what's good and what isn't good.
Exactly.
And judges are no different than anyone else. Exactly right. Exactly right. What do you think, Jay? Do we need expert testimony in literary infringement in music cases more than literary infringement cases?
Possibly, and of course, objective testimony, including expert testimony, is appropriate for the extrinsic substantial similarity test, and frankly, it is quite protective of defendants the way it plays out. I will say that the judge, in these cases, the judge hasn't just said, I like this, I don't like that. There's very detailed comparison of the purportedly similar elements in each. And since a judge is able to read, he's able to determine, assess those similarities from the point of view of anybody else, an ordinary observer, I guess. In fact, an experienced, discerning ordinary observer may be even better. I think in the expert testimony has to not only be expert, but has to be plausible. It's pretty easy to get an English professor to say, well, if these abstract themes, you can see this pattern between these types of characters, and it's easy to play with that. In the music side, in Blurred Lines, they weren't talking about abstractions. They were talking about, I think the expert manipulated them, but specific elements of similarity musically. A bass line. Personally, I think it was a scene affaire in music, the bass line. But a series of things sufficient. So there was a sufficient amount of plausible expert testimony on each side to create an issue of fact on extrinsic similarity, which then throws the whole thing to a jury, presumably both on extrinsic similarity and intrinsic substantial similarity. And I think that getting the battle of the experts in that field, I think you're right. If you really can, but the musical experts tend not, in my experience, tend not to talk about abstractions. Not to talk about, well, there's a similar mood to these two songs, although I guess they get pretty close to it with a similar feel in a Marvin Gaye tune, to a Marvin Gaye tune. There was also extremely strong evidence of access there, and in fact there was evidence of intent to use the plaintiff's work. There was an extremely unsympathetic, what we'll call defendant, even though it was the plaintiff, hugely unlikable, lying party, which didn't help anything in front of the jury.
Robin.
Robin Thicke?
I'm not saying that out loud.
Oh, okay.
But you guys can. You're litigators.
I was just guessing. I was just trying to read your mind.
But
It had to be either Robin
and so
Thicke or Farrell.
there was that going forward, and of course, the stronger the evidence of access, there is this inverse ratio rule, which itself is somewhat problematic, really, but says that you need less evidence of substantial similarity at the extrinsic level if there is very strong evidence of access. And they say the same thing about Metcalfe now. They limit Metcalfe, the cases that do discuss it, and most of them do, at least mention Metcalfe. They say that should be limited to its facts, where you had very strong evidence of access and where you have a significant number of specific elements, possibly in the same order or a very similar order, that are such that the similarity is striking between them.